Hi everyone, and welcome to our next session, sponsored by Hanson Hunter and Company PC and Axiom Healthcare, entitled Preparing for DHCS Audits. Your presenters today are Stanton Stock of Hooper, Lundy, Bookman, and Mike Lesnick from Axiom Healthcare. Take it away.
Okay, thank you for joining this presentation, Preparing for the Worst in Medi-Cal Audits and Appeals under Assembly Bill 81. Obviously, a bit of hyperbole in the title, implying that Medi-Cal audits are the worst kind of audits, but California's reimbursement scheme is certainly unique. And now that we have Assembly Bill 81, we do know that this scheme is going to be around for several more years, and the scope of what the Medi-Cal auditors are reviewing, that has now expanded to include COVID-19 relief funding. And so my colleague and I, Michael Lesnick, we wanted to convey the sentiments we get from many of our clients who have been through difficult Medi-Cal audits and faced some significant adjustments. So I thought it was a good opportunity to make a presentation aimed at really preparing providers for these audits that are right around the corner now. Two disclaimers before we get going. First of all, we're not providing legal advice. The views expressed in this presentation are our own. We are recording this presentation as of November 9th, whereas I believe it's going to be streaming the 17th. This is 2020. A lot can change in 1 week, so we just want folks to be mindful of the fact that additional guidance or developments may be coming down in the interim. With that, I want to introduce my colleague to cover the next slide. Michael Lesnick is a partner at Axiom Healthcare, which recently merged with Hanson Hunter. He is an expert in Medicare and Medi-Cal cost reporting principles. He's participated in hundreds of Medi-Cal appeals. He's testified as an expert numerous times for providers in California. Mike and I work on many audit appeals together, and it's always a pleasure to do so. Mike?
Thank you, Stan. As Stan said, the title of the presentation, Preparing for the Worst, we'll add to that, Hoping for the Best. And of course, we have dealt with Medi-Cal auditors on many audits and appeals for many years. And we anticipate that their approach to the audits of the relief money that we're going to be talking about will be similar to their approach on normal audits that they conduct. So we're going to be talking to what we have experienced with auditors and applying that to the issues that we're dealing with here. And the three key takeaways that we want to deliver today are to identify the issues that we can anticipate in Medi-Cal audits. I just spoke to that briefly. To develop a strategy to prepare for those audits, and to, of course, preserve our appeal rights, your appeal rights, through the audit process and through the informal hearing process. We're going to go through a lot of material here, and I would like to reciprocate and introduce Stan. Stan is an attorney with Hooper, Lundy, Bookman in their San Diego office. Stan specializes in representing healthcare providers, and just is an expert at all of the regulatory issues and audit issues and appeal issues that we deal with. Stan and I have done countless audit and appeal projects together, and as I've said many times, Stan is a very expert attorney. And I really appreciate being able to work with Stan on these sorts of things. So with that, let me turn it back over to Stan.
Thank you, Mike. So it should be on slide 3 here. Mike was talking about the 3 key takeaways, and then this is the agenda that we're going to use to get there. I'll spend about 5 minutes talking about Medi-Cal support for COVID-19, and that includes the state plan amendment, which gives providers the 10% rate increase, as well as Assembly Bill 81, which I've already referenced, that expands the auditor's review to COVID-19 funds. And then we're going to shift to Mike. He'll discuss some distinctions and the coordination of the federal and state COVID-19 funding. And then we're both going to talk about some significant concerns in preserving appeal rights before diving into the final topics, which is going to be covering some recurring issues or hot topics that all providers should be aware of. There are ongoing Medi-Cal appeals that are only likely to get worse under Assembly Bill 81. So let's go to slide 4. Yeah, so I'm going to spend, like I said, 5 minutes talking about Medi-Cal support for COVID-19, and that includes the state plan amendment and Assembly Bill 81. We can advance to slide 5. So Assembly Bill 1629, California's long-term care reimbursement scheme, very unique reimbursement scheme. We have occasionally worked with reimbursement consultants from outside of California, and they are just floored to see how different California's reimbursement scheme is as compared to the rest of the country. You can certainly be a Medicare expert, but not be a Medi-Cal expert, and being qualified as a Medicare expert won't necessarily get you admitted to even testify in a hearing in a Medi-Cal appeal. So AB 1629, that is somewhat cost-based. Medicare introduced the idea of cost-based reimbursement back in the 60s, but then Medicare shifted towards the PPS system in the 80s, and then 2 decades later in 2004, California enacts AB 1629, and like I said, that is a cost-based, facility-specific but prospectively determined rate system. In its simplest forms, a provider will file a cost report every year, which is audited by the Department of Healthcare Services, and then those audited costs determine provider's rate 2 years later. So in other words, the cost report that you file for 2018, that is ultimately what is driving the reimbursement rate that you receive for rate year 2020. This AB 1629 that was initially set to sunset in December 31st, 2020, just at the end of this year, but that's now been extended, which is a point that I'll get back to here shortly. Slide 6, please. So we talked about how under Medi-Cal, you're receiving this prospectively determined rate based on your cost. So now the question is, what did Medi-Cal do to help providers during the COVID-19 pandemic? In April 2020, Medi-Cal submitted State Plan Amendment 20-0024, and that amendment authorized a temporary increase, 10% increase in the rate of reimbursement that providers were receiving at the time that the amendment took effect. Now, this whole process happened quickly. Like I said, this was submitted in April, but it had a retroactive effect going back to March 1st, 2020. And so you should, as a provider, ensure that all of the reimbursement that you've received since March 1st, 2020 does in fact include that 10% rate increase. It would not be the first time we've had an issue with erroneous payment corrections not being implemented that were supposed to be implemented. In terms of when it will end, it is tied to the duration of the federal state of emergency. And that state of emergency was supposed to end July 25th initially, and then that was extended to October 23rd, and most recently extended to January 23rd, 2021, as this pandemic, unfortunately, is ongoing. Slide 7, please. So we're getting more money from Medi-Cal for COVID-19. How is the Department of Healthcare Services going to audit the use of that money? And that's where Assembly Bill 81 comes into the picture. That is Assembly Bill 81, that is a significant development for AB 1629 in general. As I talked about, AB 1629 was actually going to end at sunset at the end of this year, but Assembly Bill 81 that now extends the sunset of AB 1629 to 2024. So we know AB 1629 is going to be around for at least a few more years. like I said, significant development, many significant changes as part of Assembly Bill 81. If you are a Medi-Cal reimbursement expert, it's certainly worth a read. I put an example up there, like the changes that affect unpaid QA fees. But for purposes of this presentation, we're going to try and hone in specifically on the issues specific to changes with audits and COVID-19 funding. Slide 8, please. So with respect to audits, under Assembly Bill 81, we get an entirely new section of Welfare and Institutions Code, section 14126.032. And that is what gives the auditors now statutory authority to audit the costs and revenues associated with the COVID-19 public health emergency. And the Department of Healthcare Services, these are the same auditors that do your Medi billing reviews, your cost report audits. They will be ensuring that the increased Medicaid payments are used only for, quote, allowable costs. Next slide, please. And then another important point, in conducting these audits, the auditors may also request any information related to other revenue received. So for example, the Medi-Cal auditors will want to know what money you received from PPP. They're going to want to know what money you received from the CARES Act and what did you spend those funds on. And now we know they have the statutory authority to specifically request that type of information with the goal, the end goal, we think the auditors will be recouping any amount that they deem is not related or not used to support patient care. With that, I'm going to turn it over to Mike. He's going to talk about the next topic, coordinating federal and state sources for COVID-19.
Thank you, Stan. We are going to have a series of funding sources to justify and to talk about how we spend. And as Stan just said, the Medi-Cal auditors are going to be looking at how we've spent all of this money. I'll have to say this at this point in time, we have more questions than answers about what's going to happen when these audits come forward. But we're going to give you our best advice, our best thoughts on how to prepare for these audits and how to prepare for justifying the way that you've used the money that you're going to get. Can we move on to the next slide, please? So basically, there are a number of different funding sources. This slide shows buckets that have the PPP, FFCRA, the CARES Act grants, other funding sources, and ultimately the increase in the Medicaid rate. So you know that there's going to be different, that there are different sources of funding that you've received, and you're going to have to talk about each of those sources of funding independently because each has a little bit different set of rules that govern what you're supposed to spend that money on. Next slide, please. Because you've gotten different sources of money, you'll have to add it all together. And whatever the total is, you're going to have to talk about how you spent, how that's funding, how that relief money was consumed. You're going to have to, in quotation marks, prove how you spent it, or at least describe how you spent it. And when you spend $1, you can only spend it on one funding source to justify one funding source. So if you received PPP money and you spent it in accordance with the PPP rules, which effectively are payroll, rent, and utilities, you're not going to be able to use the money spent in that capacity to justify the other funding sources that you've received. None of the funding resources, quote, reimburse the provider for costs. In other words, they're not saying, okay, if you buy PPE, I'm going to give you a number of dollars for having done that. Now, the closest thing to that, actually, the one funding relief funding source that is most specific is the PPP money. So that specifies payroll, rent, and utilities. But you're not getting reimbursed. You're getting a pot of money, and there are certain rules that govern how you're supposed to spend that, what justifies that. And the significance of the term reimbursement is if you're being directly reimbursed for something, there's a higher likelihood that would be offset against expenses that you're incurring. We'll talk about that in the next slide. And there is a logical order that we want to do this. Again, this is a little bit duplicative, but we're going to only justify one bucket at a time, or $1 can only go into one bucket. Once you have spent a dollar on a particular source of funding and you're using that dollar to justify that bucket, you're not going to be able to count it again for another bucket. Next slide, please. Now, this is where I said we have more questions than answers in a lot of cases. Do we have to prove we needed the rate increase? For example, demonstrate increased costs. Well, arguably, you will have to prove that you needed the rate increase, or I think more accurately, the way I would portray it is you're going to have to detail how you spent the money. I think that falls short of, quote, proving you needed the rate increase, but that's just a terminology. So if we do have to prove the increased cost, or whatever term you want to use for that, do we have to prove that the increased costs were COVID related? And there again, that is a somewhat subjective way to look at that. If we are trying to prove something is COVID related, what does that mean? For example, even things like PPE, okay? You have had to deal with infection control measures for all of the time that you have been in the nursing home profession. Using PPE and dealing with infection control measures is nothing new. So why, now that we have this new virus, are we getting extra money? Well, arguably the demand and the intensity of the use of PPE is much more significant than it was before this virus. But still, you buy an order of masks and gloves and gowns and so on, and you are not going to keep track of when a person puts on a mask or a pair of gloves or a gown, how many COVID patients they saw versus non-COVID patients they saw. And arguably, we've talked about this, Stan and I and others in the group that we are dealing with, trying to put this guidance together, that under this environment, every single thing you do is affected by COVID. We've spoken with providers who have done a lot of work, and I really encourage this, done a lot of work examining their new operational realities. And the new operational realities are that virtually every single department, every single task that you do is affected by COVID-19. It will not be possible, in my opinion, to quantify that in a traditional way that an auditor might demand if they were auditing, for example, your liability insurance premium cost, where you would give them an invoice and a canceled check and perhaps a policy statement. It will be a little more expansive than that. So for example, you might have to describe what happens in the laundry today that didn't happen in the laundry before. So these are questions that we're going to aim to guide you on, aim to answer through some of the further slides that we have. Can we move to the next slide? Stan started the discussion of AB 81 and that we need to use that money for allowable costs. Well, allowable costs include patient care. Well, every single thing we do is patient care. Now, granted, there are certain things that auditors may deem not related to patient care, but every single thing we do is patient care. They give some examples, but keep in mind, these examples are always prefaced by including but not limited to. So wages, benefits, and incentives, overtime, so on and so forth. Other appropriate costs that support the delivery of patient care. Again, including but not limited to. Personal protective equipment. And again, note that the phrase support of the delivery of patient care. So if all we had to do was prove we spent money on patient care or in support of patient care, this would be a very simple set of audits because pretty much everything you spend is in that way. It won't be that simple. We are preparing for the worst. We're preparing as though the auditors are going to behave in the same manner they behave for traditional audits, and we'll keep moving down the road. Next slide, please. Coordinating Medi-Cal with the Medi-Cal rate increase, do we modify our cost reporting methodology? And one of the specific questions that comes up, when we get money from somebody, do we have to offset that against costs that we've incurred? So let me give you a quick example. If you pay an insurance premium, and at the end of the year, after an insurance premium audit, you get a rebate of insurance cost. That rebate of insurance cost that you paid for in the first place would be offset against that insurance premium. We do not believe that that would be appropriate under the circumstance we're dealing with here. That doesn't mean that an auditor might not take the position that certain things should be offset, but we currently hold the position that it would not be appropriate to offset the money you've received against expenses that you have incurred. This frequently asked question, example 1 below, supports that contention. Now, I will also say that the fact that we don't believe the auditors should offset money we receive against costs we've incurred doesn't mean that we don't we aren't prepared for them to, through their audits, suggest that we might have to pay something back. That's really the bigger issue that we're dealing with here. Next slide, please. Here's another example that supports the same thing I just talked about, where the frequently asked question supports the statement I made earlier. We don't think that money you're getting in for relief should be offset against costs that you're reporting on your cost report. With that, I'm going to turn it back over to Stan, and we're going to start talking about appeal rights and audits and hearings.
Right, so on to slide 18. Thank you for that, Mike. Should be on preserving appeal rights from audit to hearing. Before talking about the list of key risk areas, we wanted to highlight some of these key procedural aspects. And that's because we wanted to spend the remainder of the time talking about those risk areas without feeling like we missed these key considerations here. So the first consideration is prevention. What can we do before an audit to try and avoid or prevent these significant adjustments, prevent these significant overpayments? And this is an area where your compliance program can help. Cost reporting, that is a specific area that the OIG, the Office of the Inspector General, identifies for compliance auditing and monitoring. And so it's very important that we start thinking about defending our cost reporting decisions. Like Mike said, many unanswered questions at this point in time. The best thing that we can do is design a framework that will reasonably identify issues, analyze those issues, and lead to some defensible decision making. And that is quintessentially a function of your compliance program. The compliance program, the federal regulations now require that every skilled nursing facility have a compliance program in place. I cite that regulation on the slide. There's different requirements really depending on the size of your organization, but one key requirement that's going to be applicable to all skilled nursing facilities is this requirement for an annual review. That the purpose of that review is really to assess your compliance program and determine how it can be modified to be more effective. And of course, now that you have the COVID pandemic creating new issues, now would be a perfect time to really review, modify your plans to make sure that those new issues are being addressed. Next slide, please. So like I said, we want to review our annual risk assessment and identify specific risk areas and develop a detailed annual audit plan for really analyzing these issues. This slide provides a brief overview of what should be considered in designing that effective plan. Scheduling and timing, of course, that's an important factor. I think in the ordinary course, cost reports are filed in March. So we want to give ourselves at least a couple of months to review documentation in support of some key risk areas. Audit methodology, that's where you're really defining what areas you want to review and how you want to review those areas. With respect to identifying the areas, we're making suggestions as part of this presentation that you should consider reviewing. You could also look at prior year audit adjustments to see if there were any significant issues that came up that can be addressed. And of course, like I've mentioned, these regulatory and statutory changes that we're going through as a result of COVID-19, those are creating new issues in of themselves. And then finally, which personnel should participate? Getting participation from the right people is really critical. Compliance, your compliance officer isn't expected to be a cost reporting expert, but at the same time, compliance and your financial folks, they should not be operating in a silo. They should be trying to coordinate to address these types of issues. If you do use a third-party cost report preparer, consider coordinating with them to assist with these compliance reviews. So again, these are pre-audit efforts to address specific risk areas. I'm going to turn it over to Mike, and he's going to talk about actually responding to the Medi-Cal audit.
Thank you, Stan. Slide 21 talks about the three beginning, middle, and ending portions of an audit that you will experience. Virtually all nursing homes are audited every year. We anticipate that with regard to the relief money that we're getting, virtually all nursing homes are going to be audited by the Medi-Cal auditors as well. So there's three major components to the audit in terms of phases: entrance, letter, and document requests. At the beginning of every audit, you'll receive a letter, and the auditor will ask you to provide a variety of documents, a variety of information. Sometimes people have an entrance conference where you actually get on the phone with the auditor, sometimes even in person, and you talk about what's going to happen during the audit. Now, a lot of people skip that. I'm going to encourage you to request, in fact, demand an entrance conference. And I'm going to encourage you to use that entrance conference to get as much detail as you can about what the auditor is going to be looking at. And there are, generally speaking, there are a number of issues that auditors look at every single year. A good hint as to what they're going to be looking at is what happened last year. They're going to look at all those things. Now, again, with regard to the new COVID relief money, there's going to be new issues that have not come up before. Whether it be old issues on a traditional audit or new issues, what you want to do is ask the auditors to give you as much detail as you can get out of them about what they're going to be looking at, what approaches they're going to make. And this is, I think, very important. In a lot of situations, the auditors will have very strict guidelines that they are going to be obligated to follow. Their boss or somebody at the policy level in Medi-Cal has made a determination about what their position is on certain issues. And they may well make such determinations about the relief money before these audits occur as well. So if you're going into an audit and the auditor has already gotten a position on a particular issue, it would be to your advantage to understand that in as much detail as you can. So use the entrance conference to gain as much data as you can. There's a lot of records and documents that will be exchanged during the course of the audit. One of the most frustrating elements of audits for a lot of us is that we will exchange data, and later on we will hear the words or see it in writing, "I never got that. You didn't give me what I wanted. There was a lack of documentation." So again, an ongoing dialogue during the course of an audit is critical. And when you are asked to produce something for an auditor, whether it be through the entrance letter, which you're going to clarify in your entrance conference, or whether it be during the course of the audit, make absolutely certain that you keep a clear record of everything that you've produced. Keep all of the documents that you've produced in a file where you can get back to them. Make sure that they are listed if you send them via an email, list the documents that you are sending via email, so you have a good record of what's been sent to the auditors. Because there certainly is going to be a point where you get to the end of the story and they're going to say, "I didn't get something," or "You didn't give me sufficient documentation." So after the audit is wrapped up or wrapping up, you have an exit conference. Now, the exit conference is where you get an opportunity to look at the proposed adjustments that the auditors have written. And arguably, you have a chance to discuss them, ask questions about them, offer additional information about them, and in hopefully some cases, if not many cases, you'll have an opportunity to resolve issues before the audit gets finalized. Again, many times the exit conference is skipped altogether or is very cursory. And I am here again to really suggest very strongly that you demand an exit conference, a formal exit conference, and you plan to spend whatever time is necessary to go through and talk about all of the relevant issues. Some issues are going to be rather simple. Some issues are going to be truly documentation oriented. If you give me this invoice, if you give me this contract, I can make a change here. Others will be, quote, theoretical or matters of the interpretation of law. Gets back to what I said earlier. If the auditors have already come to an interpretation of a law, or have already come to a decision about what theory they're going to apply to something, the ability to work things out may be limited during the course of the audit. But they can be worked out in the appeals process, whether it be at the informal level or at the formal level. So when you get to the exit conference and you know that there's a decision that they've made, you got to find out, is this truly a documentation issue, or is it a theory or interpretation of legal matter issue? Almost every audit I've ever seen has some reference to lack of documentation as a basis for the adjustment. Sometimes that's true, but more often than not, that's not true. More often than not, even though there may be a documentation issue involved, there's a theory or an interpretation issue. So you want to take all the time you can take and ask detailed questions of the auditors, why they did this, where they got that, what's the support they're using, is this a theory, is this documentation? If it's documentation, what am I missing? And you'll often find that it really is not documentation at all. It's a theory issue, it's a pre-established issue, and then you take it further. Now you start asking questions about what they use to justify this adjustment. What study did they use? What law did they use? What regulation did they use? What guidance from their office did they use? And you want to ask for copies of all of those things. I've had in recent years a lot more time spent in exit conferences, and we've had a modest amount of success at getting things overturned, even theoretical things overturned before the audits are finalized. So I really encourage you to use that exit conference. And with regard to, at the end of that conference, you're going to be asked to sign an acknowledgement. You are not going to indicate in that acknowledgement that you agree with the auditor's position. Do not indicate in that acknowledgement that you agree with the auditor's position, you will acknowledge the fact that you have had an exit conference and that obligation has been fulfilled. But you aren't done at the end of the exit conference, because you're going to exchange data. You're waiting for a final report to come out, and so stop short of acknowledging agreement with the auditors, but do acknowledge the fact that you've had the appropriate exit conference. Next slide, please. Next slide is about what happens after you get your final audit report, which is called the report on the rate setting audit. Sometimes we call that, in short, the blue book, the audit report. You're gonna, if there are issues that you want to dispute or appeal, you fill out a request for an appeal hearing, which contains within it the statement of disputed issues. And the statement of disputed issues has some elements that you need. You need to talk about your position in brief, not a detailed position statement, but at least in brief, what is your position as a provider on the issue? What is the legal basis? What reference are you using? You need to lay out the amount that's at issue. How much was the adjustment? If you know the impact, that's great. You may only know the amount of the adjustment, and that would be appropriate too. You want to lay out the adjustment numbers. I have recently had a couple of issues where, with regard to the amount at issue and the adjustments, we put together a grid. And we submit that grid to the department. In a couple of cases, the submission of the grid via fax, they have a fax line typically that we submit this to, the grid got cut off. So the people trying to accept the appeal into the system weren't quite sure what issues were being appealed, which providers were appealing which issues. And we had to repair that by going back and submitting the adjustment grid via email and talking with people to make sure that they understood what we were doing. So there are some things that could happen. And then you get an informal level hearing. And in the informal level hearing, you're probably going to be able to clarify and resolve issues that are truly documentation issues. In some cases, again, as I said earlier, an issue will be portrayed as a documentation issue, but in reality, it's not, for a couple of reasons. One, the documentation that they're asking for, if you give it to them, is never good enough. There's always another piece of documentation, and it gets to the point often where documentation that they're asking for simply doesn't exist. Nobody does it. There are no such thing as that piece of documentation. And what you find is that there's kind of a hiding behind the word lack of documentation when truly it's a theoretical issue or a pre-established condition. So at the informal level hearing, you have another chance to really dig in and really understand why the auditor has made the adjustment and what, if anything, that you give the auditor could allow them to make a different conclusion, to reverse the adjustment. And you will find, if you take the time to do it, that in many cases, the auditor's ultimate position is, I've been told by somebody, or I've determined for myself that this is my position and nothing you give me will cause me to change my position, which of course then you state your position and a hearing officer will make a decision. Now, if you get to the point where this is a matter of interpretation of law or regulation, the informal level hearing officer is not likely to provide you any relief, because this forum, the informal level, is not designed for matters of interpretation of law. Next slide, please. And actually, I'm going to turn it back over to Stan for more, and we're getting into more specific areas here about Medi-Cal audits and appeals.
Thank you, Mike. So yeah, talking about hot topics in Medi-Cal audits and appeals, the remainder of these slides, they really address specific issues that we've worked on that have resulted in high dollar adjustments to different providers. Now that we're receiving more money for COVID-19, these are areas that are likely to be reviewed, we believe, with more scrutiny, with new layers of complexity. And these are all issues that we've had at least some success at some aspect of the appeal process in addressing these issues. So we believe there are strategies you can employ either before an audit or during an audit to increase the chances of avoiding these types of adjustments or reversing these adjustments. And these even may be some areas here where you're losing money and didn't know there was something you could do about it here. So we're going to get through as many topics as we can here in the next 10 minutes or so. But for each topic, generally speaking, I'm going to summarize the rule, and I'm going to turn over to Mike, and he's going to talk about the strategies in addressing the department's adjustments. So first major topic, we are already on slide 24, is the area of executive compensation. So again, what is the rule for executive compensation? You can look to various authorities, including the Provider Reimbursement Manual, federal regulations, but really the overarching rule is that compensation must be reasonable for the services that are related to patient care. And for determining what is reasonable, you look at what comparable institutions are paying for comparable services. If you're comparing a CFO, you should be comparing what a chain of 30 SNFs in California pays to its CFO to what another chain in California pays its CFO. And then, like Mike was saying, we do have to maintain documentation to support those costs. There's going to be basic documentation that's expected, W-2, payroll records, job descriptions, maybe CVs that reflect each individual's role and experience. But from there, we'll certainly have disputes about what additional documentation would be required, if any. So Mike's now going to go a little bit more in depth in terms of the department's rationale for some of these adjustments.
Yes, so we're moving on to slide 25 at this point. And the executive compensation is very frustrating. The slide delineates administrator compensation from other executive compensation. Now, with regard to administrator compensation, assuming we're talking about a traditional administrator who's serving a building in that capacity, the department has done a study, an administrator compensation study, that I believe is pretty reasonable. In other words, the amounts that they allow for administrator compensation are reasonable with regard to what administrators are actually being paid in the marketplace. There are exceptions to that rule, but the traditional administrator comp study is pretty reasonable. Other executives, and this generally applies to two categories: administrators who are also owners or administrators who have duties beyond their administrator duty. And the second category are executives at the home office level. So executives at the home office level, CEO, CFO, COO, vice presidents of operation, those sorts of people are not administrators. Their duties are broader than an administrator's duty. If they're at a chain level, they're overseeing a number of facilities, sometimes a very large number of facilities. And the department has no study, I repeat that, the department has no study that represents the reality of executives at the home office level. The department has no study that represents administrators with duties beyond the administration, such as owners of the nursing home who have ownership duties beyond administrator duties. And the difficulty comes in where the auditors will try to apply either the administrator study to these other people. It doesn't fit, they shouldn't do that, or go grab a study from somewhere else, such as the Bureau of Labor Statistics or some national compensation study. And we see those studies frequently. And we see numbers that the auditors proposed based on those studies, which make absolutely no sense in relation to what those executives are really being paid. And when we dig in, and this is an example of at the exit conference, during the audit, asking those auditors to explain what they're using. What does that study represent? Does it represent actual skilled nursing facilities? Or does it represent a variety of types of businesses? Does it represent California facilities? Does it represent a chain of the size that you're dealing with? Does it represent the types of services that the facilities are providing? On and on it goes. There are many, many questions you can ask about that. And we have had, again, a reasonable amount of success at getting proposed adjustments to executives who are not just administrators at the facility level overturned or put aside, both sometimes during the course of the exit conference and sometimes in actual. And we are, Axiom, Hanson Hunter and Company, we are actually conducting an executive compensation study as we speak, which will hopefully provide a much better basis for defending what gets paid to executives at that level. Next slide, please. I want to, Stan included this slide. I want to point out that there are certain provisions, and this one applies to how much the federal government believes is appropriate to spend on executive level salaries, on salaries. This is not a limitation. This is not a study. This does not apply to Medi-Cal. And if an auditor, a Medi-Cal auditor were to grab this particular thing and say, look, you can only pay people $197,000, that would be wrong. So it's kind of the same as them grabbing a study that doesn't represent the market that they're examining. This is a federal rule that has a completely different purpose and is not intended to be a limitation on how much is reasonable to pay a particular individual or an executive. With that, I'm going to turn it back over to Stan.
Yeah, and then next slide, slide 27, please. So as Mike mentioned, we have had success at challenging adjustments to executive compensation. What's on the screen is an excerpt from a final decision from the administrative level that we took to formal hearing. And the ALJ, the administrative law judge, specifically agreed with us and found that the department's reliance on a national compensation study, the NCS study, which was the Bureau of Labor Statistics, that was not adequate to support the adjustment because really, as indicated in this excerpt, the department did not establish a reasonable range of compensation paid at comparable institutions. So the takeaway here is that you do want to watch for adjustments to executive compensation and analyze whether the department is making a fair adjustment. We're coming up near the end of our time, so this probably be the last topic that we get into here. But like I said, there's a listing here of all these different key areas. But let's move on to slide 28. So the Medi billing audits, this is an ongoing issue for many years. The department keeps getting away with this in part because the overpayment amount that they recover may not be worth appealing in each individual year, but we find that year after year, these types of adjustments certainly do add up here. So what we're talking about is predominantly ancillary services that are rendered to subacute patients that are eligible for both Medicare and Medi-Cal. And by ancillary services, we're referring to PT, OT, ST, those different types of therapy services and medical supplies, such as enteral. Now, the rule, it's so simple, it can be stated in a couple of different ways. First, you can look at the definition of an overpayment. You can't keep money you're not entitled to. And when you're dealing with Medi services that are covered by two payers, there's a possibility that you receive payment from two different sources. And so you obviously can't keep the payment that you're not entitled to. And so you have to look at the two different sources of reimbursement. As discussed, when it comes to Medi-Cal, they're paying the facility-specific per diem rate that's driven by your cost in your cost report, and that's true for your subacute rate as well. And then Medicare, on the other hand, that's paying for a fee-for-service. Medicare pays the 80%, and then Medi-Cal pays 20% as a copay. So the issue really becomes, were you paid twice for the same ancillary service? Then Mike's going to walk us through the department's, the nature of these adjustments and the strategies for dealing with that.
Yes, and in the sake of time, I'll be brief. First off, the department's position on recovery of these Medi-Medi crossover payments is incorrect. Their approach is wrong. We have won some cases and we've lost some cases in that area, but we are getting to the point where we're getting closer to this. So if you get a Medi-Medi audit, we can talk to you about the details. Secondly, the Medi-Medi audit has been expanding into non-subacute. Traditionally, it's been limited to subacute. That is also wrong, and we can talk to you afterward about those details. So moral of the story is you should contest Medi-Medi adjustments. Stan will maybe squeeze in one more.
Yeah. And we've actually had success at fighting these Medi-Medi adjustments. We took this to Superior Court, and I'm on slide 31, and we did obtain a Superior Court decision in our favor where the court agreed with us. They found that the overpayment amount is the amount that Medi-Cal paid on top of what Medicare paid. You're entitled to keep the Medicare payment. That is not the overpayment. But nonetheless, notwithstanding this decision, the department really continues to make these types of adjustments. And so we continue to fight them. So let me just run through sort of the key takeaways. If we go to slide 32, cost reclassification. The key takeaways on this particular topic is that the department is reclassifying costs from your labor cost category to your administrative cost category. When the department does that, you want to be, it's a subtle change, but it can result in a significant reimbursement impact, and that's because your administrative cost center is capped. For some providers, we're dealing with, you can go on to slide 33, dealing with $600,000 per year decrease in reimbursement. And again, that is because of that limitation on your reimbursement cap. So go on to slide 34, please. And like I said, the home office nurse, that's a big one. That's one that we anticipate as you rely more so on these home office nurses, that your home office nursing cost is going to go up. Respiratory therapist reclassification, that is another significant issue that we run into year after year. And so these are areas that in some cases we've been able to settle, but due to the nature of the adjustment and the significant reimbursement impact it's having, these are issues that we continue to fight on year after year for multiple providers. So definitely something you want to watch for and you want to consider appealing if that comes across in by way of one of your adjustments. Let's go to slide 34. And those are, I'm sorry, slide 35, please. And these are the questions that come up when the department makes this cost reclassification. Going back to strategy, like Mike was speaking about, you want to try and understand what exactly is the department's basis for the cost reclassification. We find that their position can really change over time, whether or not it's a dispute over the law, whether or not they just disagree as a matter of fact. You have nurses providing nursing services, or whether or not this is a sufficient documentation issue. So again, procedurally, you want to really try and flush out and understand the basis for the cost reclassification as early as you can so that you have a chance to really fight these going through the appeals. And then Mike, I believe Mike's going to speak to the last couple topics here, the related party transactions on the next slide, please.
And I'll be very brief here. In the sake of time, the auditors and the state are more interested in related party transactions than ever before. And as a bit of an aside, there's a new law that requires more transparency. In fact, there's some new cost report forms or modified forms on the cost report that are going to require deeper disclosure of who's connected to related parties, including individuals who are ownership interests in related parties. But we can guide you again after the call, after this seminar on details related to that. Your cost report professional should be included in the process, especially when you get to the exit conference and the proposed adjustments and the audit report. And they can guide you to whether or not there's an issue that needs to be disputed and whether or not there's value in disputing it. So without time, we could spend a long time going into lots of detail, but let me leave it at that. When you get to the end of the audit, use your exit conference, get your cost report professional involved, and have them guide you as to what issues need to be appealed. And then, of course, knowing that many of those will be legal issues, you're going to need Stan to help you formulate your argument so you have the best chance of success in those hearings, along with your cost report professional. So I think that's all that I have for today. Stan?
Yeah. So the last slide 37, just related to the point that Mike was raising. We've seen some very aggressive disallowances with respect to home office cost allocations. The department wants to know if you have a related party that the home office is providing services to, they want to make sure that that related party is receiving its fair share of home office cost allocation. So certainly want to be prepared to respond to that, review how your organization is allocating home office costs to these related entities, and be prepared to respond to adjustments of that nature. So the next and final slide, that's it. We want to thank everyone for their time. We hope this presentation has been helpful. Our contact information is on the slide, and then you can email us any questions, and we're happy to talk through any Medi-Cal audit issues your organization may be facing. So thanks again.
And thanks to CAHF for bringing this presentation to you. Thank you.